In this pair of lectures, we're looking at conventional law enforcement tools. We covered subpoenas in the last lecture, and in this lecture, we're going to work through conventional search and seizure warrants, which cover physical intrusions. There are three topics on deck. First up, what exactly warrants are, and how they function. Next, the constitutional notions of search and seizure. In other words, when warrants might be required. Third, we'll briefly touch on exceptions to the warrant requirement. Fourth, and finally, we'll work through the exclusionary rule under the Fourth Amendment. So, here's the deal with warrants. A warrant is a specific type of court order. In lay explanation, it's very common to refer to all court orders as warrants. That's not at all accurate. Again, a warrant is a specific type of court order. As we'll soon see, there are many other court orders that the government can apply for. The specifics of the warrant procedure are defined right in the text of the Fourth Amendment. It's called the Warrant Clause, and it says that no warrants shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Let's break that down. The first part just explains that this is the procedure that governs all warrants. Period. If something falls short of this procedure, it's not a warrant. The next part tells us the substantive standard required for a warrant. That's probable cause, which we'll return to soon. The third part explains how probable cause is established. It's a sworn statement by a government officer. The statement is usually provided in a somewhat formal write-up. That's called an affidavit. The last part is usually called the particularity requirement. It mandates some specificity in what the warrant covers. Alright, let's start with the sworn statement requirement, then turn to the probable cause and particularity requirements. So, to get a warrant, an officer tells a judge why they believe probable cause is satisfied. Let's suppose Peter swears that he saw Alice steal from Stanford and take the loot home. To get a search warrant for the loot in Alice's home, the officer will usually write up an affidavit and a proposed warrant. Many jurisdictions also allow for hearing warrant applications by phone and have a judge on duty at all hours. So the warrant process can be fairly informal and can happen very quickly. The judge then needs to decide whether the warrant application has demonstrated probable cause and whether the warrant would be sufficiently particular. So, if Peter just wanted to ransack Alice's home, there would be no probable cause. And if Peter wanted an unlimited search of the home, not just to find the loot, then the warrant wouldn't be particular. Finally, the judge makes a decision. They can issue the warrant, or they can reject the application. Sometimes the judge will also write an opinion explaining why they approved or rejected the application. I want to make two quick notes about warrant procedure in federal law. First, warrant applications are usually heard by magistrate judges. They have many of the same responsibilities as Article III judges, but they don't hold lifetime appointments. Second, the procedure for federal search and seizure warrants is extensively detailed in Federal Rule of Criminal Procedure 41. You should always start there if you have a federal warrant question. Third, federal and state warrant procedures generally require some form of notice to the person whose physical property was searched or seized. Jurisdictions differ on the specific format and timing, and we'll see in the next part of the course that data search warrants don't include a notice requirement. Alright, now let's discuss probable cause. And I want to use the Supreme Court's own language, because I want to fully convey just how amorphous this concept is. Probable cause is an assessment of probabilities in particular factual contexts, that is not readily reduced to a neat set of legal rules. It's a judgment considering the totality of the circumstances, informed by the factual and practical considerations of everyday life. Ultimately, a judge needs to find a fair probability. So, if you're looking for hard probability math, you've definitely come to the wrong place. This is really up to a judge's discretion. There are two well-established points about the probable cause standard that I want to call out. First, there's a popular misunderstanding that probable cause means better than even. The Supreme Court has made clear that that is not the case. Probable cause does not mean over 50%. Second, a totally anonymous tip is not enough to establish probable cause. It has to be corroborated by other evidence. Beyond that, again, it's largely up to a judge's discretion. So, that's probable cause. Now let me say just a few words about particularity. The idea is pretty straightforward. A warrant should provide clear guidance, such that it limits officer discretion. It's the judge who sets the terms of the search or seizure, not the executing officers. The history of this issue is very clear. Before America was independent, British officers would routinely execute so-called general warrants, which were unlimited. The Fourth Amendment rejects that practice. There need to be clear rules. The practical effect of the particularity requirement is that it scopes probable cause. In the earlier example, Peter had probable cause to search for stolen property in Alice's house. He didn't have probable cause with respect to the house as a whole, so he couldn't search parts of the house where the stolen property wouldn't fit, couldn't rifle through papers, futz with computers, and so on. He also had to stop poking around the house once he found the stolen property. So, that's how particularity scopes probable cause. And that's all I wanted to say about particularity. Enough about warrants. Now let's turn to searches and seizures. The Fourth Amendment protects against unreasonable searches and seizures by the government. When approaching a particular practice, courts start by asking two questions. First, was there a search or seizure? And second, if there was it reasonable? Let's look at each of those two questions. With respect to whether there was a search or seizure, courts might find a search, or they might find a seizure. A rough distinction between the two is that searches are about seeking information, while seizures are about substantial interference with property and people. That distinction holds up pretty well in conventional physical searches and seizures. If Peter pokes around Alice's house looking for some loot, that's a search. If Peter confiscates some of Alice's belongings, or arrests Alice, then that's a seizure. In electronic searches and seizures, however, the distinction quickly gets very blurry. The rest of the course is going to focus mostly on searches, since that's how surveillance cases tend to get litigated. There are some hints of jurisprudence suggesting that seizure doctrine applies to surveillance, though it tends to get conflated with search doctrine anyway. In the next lecture, we're going to dig into the specific tests for whether a search has occurred. There's a final category here, of course, and that's government conduct that's neither a search nor a seizure. Historically, the Supreme Court used this category a lot. Either something was a search and seizure, with all the usual trappings, or it was totally outside the Fourth Amendment. In particular, we're going to soon see how metadata falls into this category. The modern trend, by contrast, is to find a search or seizure, but to apply some lesser requirements. So, let's turn to those substantive reasonableness requirements. The default rule is everything we've just seen. A warrant supported by probable cause with particularity. That's the default. There are, however, a number of areas where the courts have made exceptions to the default. This is the modern trend. Instead of saying something isn't a search or seizure, the courts will make a special intermediate rule that's less of an imposition than a warrant. So, now let's turn to those exceptions to the warrant requirement. There are quite a few, and I just want to touch on a handful that we'll circle back to later. One category of warrantless search and seizure is the temporary stop, sometimes called a Terry stop or stop and frisk. For example, if the police stop you on the street or pull over your car, there's a special intermediate set of Fourth Amendment rules that apply. We're going to circle back to this category soon, since federal privacy statutes borrow from it. Another category is the so-called special needs branch of the Fourth Amendment. It originally applied to administrative searches and seizures, such as inspecting a business's records, but it has greatly expanded over the years. We're going to return to the special needs branch when discussing foreign intelligence. The search incident to arrest exception allows a warrantless search of an arrestee's possessions, in theory to protect officer safety and prevent destruction of evidence. Until 2014, many courts held that this exception allowed police to search electronic devices. In the recent Riley case, the Supreme Court held 9-0 that the exception does not apply to electronics. The last exception I want to touch on is plain view. It allows police to seize contraband when it's visible from a place they're allowed to be. Plain view has been quite difficult to apply in searches of computers, and we'll look at that soon. Again, I want to note that these aren't the only exceptions to the warrant requirement. There are quite a few others. Before concluding that a warrantless search violates the Fourth Amendment, you should always be sure to check case law and consider whether an exception to the warrant requirement might make sense. Okay, that's all I wanted to say for now about exceptions to the warrant requirement. Next up is the exclusionary rule. The rule is pretty simple. A criminal defendant can move to suppress evidence that was obtained in violation of their Fourth Amendment rights. So, it's an evidentiary rule that applies in criminal cases. A corollary to the exclusionary rule is that a criminal defendant can also move to suppress derivative evidence, that is, evidence developed because of the Fourth Amendment violation, as so-called fruit of the poisonous tree. There are exceptions to the fruits doctrine, where evidence arrives from an independent source, or where the evidence would be inevitably discovered. Those can be pretty tricky for prosecutors to navigate. So, thus far, the exclusionary rule seems quite protective of constitutional rights. But there is an enormous exception to the exclusionary rule, and that's where police officers act in good faith. The idea is that the exclusionary rule should exclusively serve to deter misconduct, and where the police make an understandable mistake, there's no benefit to letting a criminal walk free. The cynical take on the good faith exception is that the current Supreme Court dislikes the exclusionary rule and is whittling it down to the extent possible. In a sense, the good faith exception is like the qualified immunity of the Fourth Amendment's exclusionary rule. Whatever the grounds for the exception, this much is certain. The exception has blossomed such that it is swallowing the exclusionary rule. Let me touch on a few places where the good faith exception clearly applies, according to the Supreme Court. First, if a search or seizure was pursuant to a warrant, the exclusionary rule almost never applies. A defendant has to show there was a defect on the face of the warrant, say listing the wrong address, or that the police lied, or that a judge was totally in the tank for the police, or that there wasn't anything close to probable cause. Short of glaring errors like those, a warrant equates to no suppression. Another important area where the exception applies is when a search or seizure is pursuant to a statute. So long as the statute isn't obviously unconstitutional, there's no suppression. We're going to see an instance of this with government access to email. The net effect, much like qualified immunity, is to give law enforcement a freebie before a statute is invalidated. Mistakes by court clerks are also enough to prevent suppression, as are even mistakes by a different police department. So, even if you think the Fourth Amendment was violated, always make sure to think through the good faith exception. Okay, so there's the exclusionary rule, the fruits of the poisonous tree doctrine, and the good faith exception. That brings to a close what I wanted to say about conventional searches and seizures. In the next part of the course, we're going to get into the basic mechanics of surveillance law. We're going to start with telephone snooping, then we'll move on to modern information technology.